Are the parties ready on the front? May proceed.
May it please the Court. Good morning, Your Honors. My name is Steve Rosen from Tampa, and I'm here today representing the appellant, Paul Hasleiferiou, who was the claimant in this workers' compensation claim below. Mr. Hasleiferiou sought workers' compensation benefits under Florida jurisdiction, but that claim was denied by the Judge of Compensation Claims, and this appeal followed. At the outset, I would like to state that the statute that we are dealing with is 440.09 sub D sub 1, which states in part, if an accident happens while the employee is employed elsewhere than in this state, which would entitle the employee or his dependents to compensation if it had happened in this state, the employee or his dependents are entitled to compensation if the contract of employment was made in the state or the employment was principally located in the state. With that, I'd like to reserve 2 minutes for rebuttal.
Okay, the clock will be in front of you. I'll try to remind you that.
When this case came into my office, I was familiar with the statute, although it's not used very much in workers' compensation law. And when the facts were given me, it seemed so simple that jurisdiction should be in Florida. But then, as lawyers do, I analyzed the case and I overanalyzed the case, and by the time we got to trial, there were many pertinent facts that came out before the judge, and the judge chose to rely on pertinent facts rather than the salient facts that would be dispositive of the issue. And so,
well, didn't he have the discretion to do that? It seems like we've got some things here where this contract would have been done in Florida, but for the paperwork clog up that they experienced, and they just handled it in Alabama as a matter of convenience. Is that what you're saying? Is that the contract truly was Florida? They just moved it up there for Alabama, for convenience purposes?
The contract never changed. It was made in Florida, same main employer who controlled the details of the work.
What contract are we talking about here? It seems to me, in your brief, you talked about the contract between P&H and Labor Ready. That's not an employment agreement.
It's an employee leasing agreement.
Right, but isn't the employment agreement under Florida law the agreement between the claimant and the appellee here?
In a right-to-work state such as Florida is, it's rare, if ever, that an employee who is a laborer signs a specific contract with any employer. It's usually just come to work, go to work, get paid.
But isn't there a contract here, or did I misread something?
On page 114 of the transcript, there's a letter from Labor Ready to P&H Stucco, basically, that says, you sign and we'll sign, and we agree to take your employees, make them our employees for purposes of insurances and payroll, and then we'll give them back to you so that you can control the details of their work and get your jobs done. And that's
right there, though, Mr. Rosen. Didn't they take out the withholding and Social Security and everything in Alabama and listed that your client as an employee in the state of Alabama, and they had the right to reject his employment status?
They did exactly the same thing in Florida in the 10 months that they had the agreement before the job in Alabama began. It's just that the work was done in Florida, so they took Florida withholding and taxes out. The contract stayed in place. Only the workers moved up to Alabama, and of course they're subject to Alabama taxation laws. But there's never anything that gives them a new contract, a new policy of workers' compensation, a new accord, which are all in the record. Everything stayed in place except the place of the job.
Wasn't that contract serviced in Alabama?
The contract,
rather than Florida?
Your Honor, the contract was for service in Florida in the 10 months before they went to Alabama.
But I think Judge Van Nortwick makes a good point. Which contract are we talking about? I'm talking about the contract that apparently is between the claimant and the firm up in Alabama.
The business of P&H Stucco, of which the claimant was an employee, is actually who entered into the contract. And of course they had to have employees to seal the deal, to do the work. And they brought the claimant, who was a part owner in the company, they brought him and other workers up. It wasn't just the claimant. They brought their crew up to do the same job in Alabama that if that bridge work had been done in Florida, would have been done the same way.
But under the Florida statutes, 468, 529, cited in your brief, the statute provides that a licensed employee leasing company is the employer of the leased employee. So isn't the employment relationship here between the leasing company and the claimant?
This court has held in Folds versus Metric Constructors, Inc., which was a case regarding a lawsuit by an employee against the hands-on employer that was held through an employee leasing company. And this court held that immunity from liability described in subsection 1 shall extend to an employer and to each employee of the employer which utilizes the services of the employees of a help supply services company as set forth in the Standard Industry Code number 7363. When such employees, whether management or staff, are acting in furtherance of the employer's business, an employee so engaged by the employer shall be considered a borrowed employee of the employer, and for the purposes of this section shall be treated as any other employee of the employer. In stating that, there's no delineation as to who or which employer is the employer, the hands-on controlling employer or the leasing company. And so I believe this court has held for purposes of immunity in workers' compensation that they stand in each other's shoes, and that should be extrapolated and extended to all situations of employee leasing. And that's why I think in my brief I said this may be a case of first impression, where you have a leasing company who takes over the payroll and employees but gives them back to the controlling company.
I want to ask you a question. I'm going to ask opposing counsel the same question later. Let's assume that this contract between the appellee and the claimant had taken place in Florida rather than Alabama. Would there be any doubt, in your view, under Florida law that he'd be entitled to workers' compensation benefits?
No doubt whatsoever, Your Honor.
So the deciding factor is the fact that it was serviced in the Alabama office of the appellee. Is that right?
That's correct. If you look at the statute, I don't believe, in the 32 years I've been practicing, I don't believe that 44009 D1 has been amended. And it may not have been amended since the inception of workers' comp in Florida back in the 1930s. And the legislature has whittled benefits and choices down to workers over the years. But this is one statute that gives the ultimate choice to the worker as to which law he wishes to be paid under, the state in which he's hurt or the state of Florida where the contract is made. And I believe the claimant satisfied both prongs of the test in 44009 D1. Should be awarded benefits under Florida law. Thank you.
You'll have about 3 minutes. Happily may proceed.
Good morning, Your Honors. May it please the Court. My name is Ben Winter. I represent the appellees, ESIS Insurance Services and Labor Ready, who is was the employer in this case. First, I would point out that all the work that occurred in this did take place in Alabama. It's uncontroverted.
Counselor, I want to stop you right there and ask you the same question I just asked opposing counsel. Now, assuming that this contract had been handled by a Florida office for the appellee rather than sent to Alabama because they were overloaded with paperwork, is there any doubt that under Florida law he would be entitled, the claimant would be entitled to benefits?
Your Honor, that would depend on whether or not the hiring decisions were made in Alabama or Florida. If under the case law, which is cited, and specifically Maccabee versus Nelson Construction, it talks about not only the contract but also the hiring authority of the employer. And in this case, if that would have been in Florida as well, then yes, I think it would have been something under Florida law.
But you're saying there were some decisions that were to be made in Alabama that kept a contract from being consummated in the state of Florida.
That's correct, Your Honor. There's uncontradicted testimony from the representative of Labor Ready from Alabama, which indicates that they had the ability to accept or reject any employees which were sent or which applied at Labor Ready at that time.
So is it crucial to yours prevailing in this case that your client had the authority to reject in Alabama or accept?
Yes, Your Honor, under the test set forth in Maccabee Construction.
That's the linchpin around which case?
Yes, Your Honor.
Corbett's?
Yes.
Okay, thank you.
As the appellant stated, the applicable section in this case is Section 44009, which sets forth the two-pronged test. The salient facts in this are that the work which is at issue was performed in Alabama between October 2003 and December 2004. During that time, the appellant worked the entire time in Alabama. There's no indication that he worked at all in Florida. As a result, it appears clear that the employment was principally located within the state of Alabama. The other section, of course, is the contract of employment. The salient facts with regard to that are that the First of all, there is no contract of employment in the record. If you review the record, it does not appear there is any contract of employment between either Mr. Hazel Efferu and P&H Stucco or Mr. Hazel Efferu and Labor Ready. In this particular case, an application was apparently completed by Mr. Hazel Efferu, but that is not contained in the record. All of the work that was done by Labor Ready was done through Alabama, from the Tuscaloosa office, which turned out to be about 2 blocks from where they were performing the work. The accident obviously occurred in Alabama.
But let's go back to this. There's no written employment agreement in the record. But the statute says the employee or his or her dependents are entitled to compensation if the contract of employment was made in this state, and it goes on. What are the facts with respect to the employment relationship? Was it entered into in Florida and then the employee was shipped to Alabama?
The testimony of the Labor Ready representative was that all of it was done in Alabama. That at the time they came in Alabama was the time that they met with them as well. There was some faxing of documents back and forth between Alabama and Florida.
So he never acted as a leased employee in Florida?
Your Honor, I'm not certain about that. That's not contained in the record as in the past if he had acted as a leased employee. During the time in question, it is the testimony of the president.
There's no fact in the record that would reflect that he acted as a leased employee in Florida?
Not during the time it's in question, Your Honor.
Okay, if he had, would he have been entitled to workers' compensation in Florida?
Your Honor, in this particular case, I don't believe that he would have, and the reason I say that is because Labor Ready is a temporary employment agency, and that's reflected both on the certificate of the binder of insurance as well as some of the letters which were referenced by the appellant in numbers 111 through 118 in the record. It's referred to as temporary employees. These employees were on a project basis, and these were not long-term employees that would stay with a company for years and years and years necessarily as much as they were temporary employees.
Your position is if there was an employment contract, even if it was an implied employment contract, it was for each individual project rather than a course of employment?
Yes, Your Honor. There is no record evidence of any sort of Florida employment contract with Labor Ready, and Labor Ready is the employer under the statute which was cited, the 468-520. I would also point out that there was no indication that any sort of contract of employment was made with either of the potential employers in this matter. For that reason, we believe the judge at the trial level correctly found that the jurisdiction for this claim lies in Alabama.
Okay. One last question.
Yes.
According to my examination of the record, the appellant's wife testified that at the time the original contract was entered into, there was no work going on in Alabama, period. It was just in Alabama and Georgia. But they said, we want you to go to the Alabama office because our paperwork's overloaded. Now, is that true?
Your Honor, that is reflected by the testimony from the representative of P&H Stucco. It contradicts with the testimony of Variety Wotrang in this matter, in which she indicated that she didn't have any indication that they had contacted the Florida office in the first place, and that everything did come to Tuscaloosa because of the choice of Mrs. Hazel Efferu to call Tuscaloosa eventually.
Well, would you agree with the factual representation from the record that there was no work going on with the P&H here in Alabama at the time the contract was entered into?
Your Honor, could I clarify which contract you're referring to?
I'm talking about the one originally between the claimant's employer and your client.
Okay. Again, it's my client's position that there was no specific contract entered into. The first correspondence, which is in the record, was in January of 2003, and at that point it appears that there was no work going on in Alabama.
There was no work going on in Alabama.
Correct.
And the Alabama office was doing the mechanics of it because of the overload in Florida. Is that right?
Your Honor, I don't know what the reason was, but at that point the Alabama office was handling the
Well, it seemed like there must be some reason that escapes me when they first started talking and negotiating and setting up the deal. There wasn't even any work in Alabama. it was in Georgia and Florida, yet an Alabama office executes it.
That's the way it appears from her testimony.
Okay, that's right. Thank you.
Thank you.
Thank you, Your Honors, for a brief rebuttal. And with all respect to counsel, I believe there's ample evidence in the record to show that Mr. Hasleferio worked as a leased employee from January of 2003 until they went to Alabama in late 2003. And I would like to cite the record at page 27. Questions of the employee leasing company representative. Okay, are you familiar with the company by the name of P&H Stucco? Answer, yes.
So let me get you correct. Your position is that page 27 will reflect that there was a continuous employment relationship, that there was no break.
That's correct, Your Honor. Okay. And also I'd like to refer to page 116 again, which is what I refer to as a contract between Labor Ready and P&H Stucco, which tells P&H Stucco what Labor Ready is going to do for them and how they will supply employees. And this contract was January of 2003, some 10 months before they went up to do the Alabama job.
Could you enlighten me on why Alabama got into this situation when it seemed like everything was taking place in Florida, even no work in Alabama at the time the Alabama office came in?
It's really odd, Your Honor. If you look at all the correspondence and the testimony, the correspondence was faxed from the Tuscaloosa office to my client's office in Florida at P&H Stucco and faxed back. And when the payroll came up while they were doing work in Florida before October of 2003, Mrs. Hasleferio would send the payroll records up to Tuscaloosa and they'd send the checks back. So when they got this job in Alabama, just out of sheer coincidence, it was like 2 blocks away from the office in Tuscaloosa that they've been dealing with. So instead of sending the payroll information, she just walked it over and brought the checks back. So that may be confusing to the Alabama people for Labor Ready, but in fact it was just a continuation of what had happened in Florida for several years.
Before they went to Alabama, how long had this arrangement been going on between claimants, employer, and Labor Ready?
The record clearly reflects it was January of 2003 until October of 2003, continued until the accident in December of 2004.
And prior to the claimant's employment by the leasing company, was he employed, does the record reflect whether he was employed by P&H?
By P&H for years.
Okay.
For convenience, in January of 2003, P&H decided to go with this employee leasing to get cheaper insurance and have the payroll done.
And all of the, or principally all of the employment activities prior to that time were in Florida?
And the employees, yes.
Right.
That's all I have in rebuttal. Thank you, Your Honors.
Thank you very much. The next case on the docket will be Autumn Smith versus the State